Thank you, Janet, and thank you very much to Canada Arbitration Week for having us today. So this session is organized by Arbitral Women and ICDR Canada. And just want to, on behalf of ICDR Canada, I just want to say how grateful I am to be here with you. So ICDR cases have marked for several years as Canada and Canadian parties as the major or more represented nationality in our caseload. So I'm very happy to be here and just become, as much as I can, part of this wonderful community. And let me also take just a couple of minutes to introduce myself. So I am Yanett Quiroz. I'm a Mexican licensed attorney. I've been with the ICDR for 10 years. And I recently took over the outreach and development of Canada, Mexico, and the US. So this is, for me, like discovering a very new part of the world in terms of arbitration, and it has been amazing. So I'm very, very grateful for you and all the welcome that I've been experienced so far. So, and I think that's for ICDR Canada, and then I will give us just a few comments about Arbitral Women.
Can you hear me? Is this on? So hello again. I've recovered from my defeat earlier today, and I'm very pleased to be here as part of this panel and a longtime member of Arbitral Women. I can't count the years, many years, more than a decade, 2 decades, I think. And Arbitral Women is an organization that was co-founded by Louise Barrington, together with Mireille Philippe in Paris. I think you were both in Paris at the time, at the ICC together at the time, more than 30 years ago. We just recently celebrated Arbitral Women's 30th anniversary, so I do believe it is the first and leading organization promoting women in international dispute resolution, which encompasses arbitration, but also encompasses all other forms of international dispute resolution. And it has grown from a small organization back in 1993 to a very large global organization now, with many members, seasoned members who've been in the field for a very long time, as well as younger members. And we have now, or Arbitral Women now has a young group, as well as who are full-fledged members of Arbitral Women, but a group dedicated to developing the professional experience of young women. And Arbitral Women has so many activities that they do and so much that they give to the women who are members. So we wouldn't have time today to go through it all. But I think that the principal takeaway I'd like to leave you with is that Arbitral Women is focused on amplifying and promoting its members in the international dispute resolution community. So if you are a member of Arbitral Women, you complete a profile, which is essentially putting your credentials, your CV components onto the website, which is outward facing, and everyone is encouraged to fully complete their profile so that when people are looking for practitioners in arbitration or arbitrators, they can go to the Arbitral Women website and search the members directory, which has a number of drop-down fields. You can look for people with specific expertise, language, regions of the world. It's really a wonderful resource if you are looking for practitioners or arbitrators. It also holds a number of events which are not limited to women. Arbitral Women events are open to men and women, open to everyone. And so one of the misnomers about Arbitral Women is that it's only about women. Its membership is women, but it's really open to the community. And we have events that feature women in different sectors to show their substantive expertise. Our events are not focused on diversity and promoting diversity. It's rather showing the talent that women and our panelists, men and women, have in the space, and thereby showing the ability of women, as opposed to promoting diversity in the name of diversity. Finally, I think one of the most important aspects of Arbitral Women for its members is its mentorship program, and I think you'll hear a bit more about that later from Louise Barrington. But I was a mentee and then a mentor, and I very much enjoyed that experience. And I guess I forgot to mention that I joined the board of Arbitral Women in 2016. I served on the board for 6 years, and 4 of those years I was president of Arbitral Women, and I stepped down from that role in 2022. So if you have any questions about Arbitral Women after this, I'm happy to answer them. Louise is also very obviously the go-to person to answer any questions on Arbitral Women, but I think it's wonderful that Canada Arbitration Week has an event that includes Arbitral Women. I think Arbitral Women has been a part of many arbitration weeks around the world, which reinforces the fact that the arbitration community really does embrace diversity and gender diversity, and we're very grateful to that. So with that, I'll turn it back over to Yanett. Thank you.
Thank you, Dana. And the topic that we will cover today is how to get appointed and own the role. As you may understand, ICDR Canada as an institutional arbitration, we are very, very keen to get the right arbitrators and obviously get a very good quality of that. So far, we have more than 80 arbitrators in Canada serving in our cases, so we're very, very eager to increase that number and obviously have more people involved. So in order to cover this topic, I'm here sharing the table with these amazing people that I'm gonna introduce you. I'm just gonna use a couple of minutes for each of them, but I can go hours and hours with their experience. So let me just make a quick comment about what they do. Iris Antonius, here on my left, is a partner in the Litigation and Dispute Resolution Group and co-lead of the National Arbitration Team at Blake, Castles, and Graydon. She has a broad-based commercial dispute practice with a focus on international commercial and investor state arbitration. She writes, speaks, and advises on arbitration, Canada's international investment treaties, and interprovincial trade agreements. She is a fellow of the Chartered Institute of Arbitrators, member of the Young Canadian Arbitrator Practitioners, and an advisory board representative with the Institute of Transnational Arbitration. Louise Barrington has a Canadian Ontario practice. She is a fellow and chartered arbitrator and accredited mediator with extensive international experience in the areas of commercial, corporate law, employment, and insurance. She has arbitrated cases in several regions of the world, including Asia, Europe, the Middle East, and Canada since 2009. She has worked in York University, Clinton College, Juris Doctor from the University of Toronto, and a master's degree in international private law and European law from the University of Sorbonne in Paris. Louise is the founder and past president of Arbitral Women and a member of the ICDR panel. Let's move to Christina. Christina Doria is a partner in Baker McKenzie's Toronto office and co-chair of the firm's International Arbitration Group in North America. She has extensive experience in complex business litigation and arbitration. She has appeared before the Supreme Court of Canada in different domestic and international tribunals. Christina is recognized by several ranking institutions, including Lex Expert, Best Lawyers Canada, and Legal 500, and this year was shortlisted for the Women in Business Law Americans Awards, Arbitration Lawyer of the Year. Christina also serves on advisory boards for ICDR Canada and Young Canadian Arbitration Practitioners. Then Timothy Hughes, he's an experienced advocate in complex commercial disputes, including commercial arbitration, investor state disputes, and interstate arbitration. After relocating to Calgary and being called to the Alberta Bar in 2022, He started an independent practice as an advocate and tribunal secretary. With a view to developing a pipeline of arbitral appointments, he is an editor of the Investor State Law Guide and was appointed by the Mayor of Calgary to the quasi-judicial tribunal that hears appeals related to real estate development. And last but not least, Dana McGrath is an independent international arbitrator based in New York with over 2 decades worth of experience as counsel in international arbitration disputes. Dana serves on the AAA ICDR Council and co-chairs its large complex case committee. Dana served as president of Arbitral Women from July 2018 to June 2022, and currently serves on its advisory council. So if you have any questions, this is a real group that you should ask those. And then let's go to our topic, and to start with it, I would like to go over Christina and ask her, once you receive your first appointment as an arbitrator, what are the immediate steps you should take to prepare effectively for a case?
Thank you, and I think thanks on behalf of all of us for those really lovely introductions. So assuming now you've cleared conflicts, you've been appointed, you've gone through, at least if you're at a firm like I am, you've gone through all of the red tape, and you can actually take on the appointment. I think the first thing you need to do is, obviously, you're affirming your appointment, and this varies as well, depending on whether it's ad hoc or you're with an institution, but you want to familiarize yourself. You need to understand the terrain. So, what are the pleadings? What's been shared so far between the parties? Read those. Is the arbitration agreement in there? Read it. What does it say? Do the parties agree about the governing law of the dispute? They may not at this stage. So what's the governing law you're going to be dealing with? Do you know yet? What's the procedural law? Do the parties agree on the seat of the arbitration? And so really you're looking at all of the different pieces, because the beauty of arbitration is that it's a little bit different in each case, right? And you can have this situation where you have different rules applying, different legislation applying. Is your arbitration international or domestic? So you need to know, do I have rules? Do I know the place of the arbitration, the lex arbitri? Do I know the substantive law of the arbitration? If I know the place of the arbitration, then what legislation am I under? And so you really need to get this orientation at the beginning, and it's part of preparation, right? So that's what you need to do as arbitrator, and then you'll be able to know how am I going to guide this case forward, what are the right questions that I need to be asking, and so I think that's it. At the beginning of an arbitration, I will also email the parties to set up a procedural meeting. I like to share an agenda. Your agenda, at least my agenda, is usually dealing with preliminary matters, and it's almost like if you would look at a procedural order, you're taking the headings, right? So what do the parties agree on? Let's get the parties to think about these issues before the procedural meeting, and you can do that by sharing an agenda. And then at least at the procedural meeting, you know, okay, what is it going to look like? What are exchanges going to look at? Do we all agree about how service is going to happen? At the first procedural meeting, lawyers are usually very nice to each other. And I like to get parties to agree on whatever we can agree on and get everything, like set the stage really nicely, make it clean, make sure you understand your terrain so that the rest of your arbitration can go quite smoothly. Anybody else want to weigh in on, like, what do you do when you first get that appointment?
Well, I just had a question to add in terms of the initial letter to the parties. Do you give them a direction to meet and confer in advance and come up with any agreements? And to what extent do you want them to agree things in advance, or to come to you at the procedural conference with a discussion or some view that you will then ultimately determine?
So I do in an email say, I welcome the parties to think about these issues before the procedural meeting. And I actually have a case right now where we had the procedural meeting. A lot was still left up in the air. They said, oh, we like the idea of a Redfern schedule, and there were a few things that needed to be ironed out with the timetable. So we're just going to have another procedural meeting next week because they're going to go back and see where they can agree. And it depends. So if you are getting your first appointment, you're probably not going to have like a Norton Rose and a Blake's as counsel. You're more likely to have sole practitioners who are primarily litigators, or like I had in my first case, self-represented parties. And those are the cases where you have to actually do a lot more work as arbitrator and really know the process, because your parties are not necessarily giving you like a nice procedural order that they're both comfortable with. Instead, you might have to canvas a lot more issues. And I think as arbitrator, if your duty is to make an efficient proceeding, then help the parties along with that, right? Allow them to confer and to come to an agreement, and where they don't, hear their proposals, and then decide, right? Move it along. So that's kind of my approach.
I'll just add something as the American on the panel, one of the few Americans in the room. I feel that as an arbitrator, part of my role in the initial meeting, case management conference, or preliminary hearing, however you style it, is to help educate U.S. litigators who've spent most of their life in the U.S. courts about how arbitration differs from litigation, so that you get off on the right step and hopefully reduce the amount of Americanization of the litigation process ending up in the arbitration. And sometimes I'm more successful than others depending on the experience of counsel. But that issue comes up often. So I do, and I know that many other Americans have the same goal, to try to ensure from the outset that the arbitration will not resemble a U.S. litigation. Another thing that I try to do is get a sense of how different the parties and their counsel are with respect to their legal background and their understanding of the process. Because if you have counsel from different parts of the world, they may have very different ideas of how a process should play out, and even a different understanding of vocabulary that's used. Like, for example, I had a case where the word deposition was assumed to be understood the same by both sides, and halfway through the arbitration it was very clear that that word was not understood the same by both sides. And there should be no depositions in arbitration for the most part unless it's agreed. It was agreed. It turns out what had been agreed was not really an agreement, because they had such different understandings of the words. So you do try to get a sense of the background of the counsel and the parties at the opening conference as well.
Yeah, I think that's very important. Preparation is the key. I think what you just said about, learning about the rules and all the pleadings, and learn also about the parties and their backgrounds from what you have in the record, but also be open to flexibility during the actual preliminary hearing or first hearing with them, right? Because there might be changes things that will change the whole framework.
One little thing. The other thing I'll add is, no matter how experienced you are, I still crack open arbitration law in Canada and literally go through, first procedural meeting, like a checklist. Why not? So use that. And then the other thing is, use your community. So if you want more than, if you want a few draft procedural orders, talk to other arbitrators. If you need a terms of appointment, again, talk to other arbitrators. You can share those as redacted, right? So especially where you're operating on your own, use the community. And so, I would say, I think we should all, especially for younger arbitrators, like, reach out if you need to reach out.
Okay, so then let's take a little step before that and talk a little bit about how do you promote yourself as an arbitrator before getting that first appointment. Any thoughts on that, Dana?
Well, if you're a woman, you join Arbitral Women.
Step one.
No, I think that promoting yourself as an arbitrator is different. It really turns on your personality. But some of the things that I think can be effective are attending conferences like this so that you build your network. Your network includes both mentors, people who you look up to and aspire to be someday, as well as your peers. I think peer mentorship is sometimes undervalued, and your colleagues will be your colleagues for your career, and so that's important. I think writing on topics of interest is useful. I think presenting at conferences can be useful. I think joining committees is important, but not just joining committees, but actually contributing to the work product of that committee. So if they're writing a report or working on a task force, if you can really contribute to the work of a committee, that makes that committee worthwhile. Joining 8 different entities and just sort of showing up at meetings and not being a part of the work product is less helpful. I mean, it helps with networking, but really being a part of the work product of the committee, I think, is very useful.
Please, Louise.
I'd just like to echo that comment about the committees, because I have on occasion been aware that one or more people have joined 2 or 3 or 4 committees and have not really done anything except go to the meetings, even perhaps not reported on what happened in their committee meetings to the public or to the head of the organizations. And it's counterproductive, because you begin to get a reputation. Oh, well, she's on 14 committees, but she doesn't actually talk. She never says anything. We don't know what she's there for, except maybe to have it on her CV.
I have an add-on to that. For the younger lawyers in the room, when you join a committee and you contribute to the work product or you propose a project and you do it, I'll give you an anecdote. The message is that any contribution that you make doesn't go unnoticed. So I was the secretary to a New York City Bar Committee that focused on international dispute resolution, and I'm also a passionate vis moot coach. So I decided that New York needed more, or at the time needed more pre-moots. And so I proposed that the New York City Bar organize a vis pre-moot, which meant I organized the vis pre-moot. Now there's a plethora of pre-moots, but at the time I did this, there really was not, and it was to try to help the U.S. teams have that experience. And that was successful, and that was that, and I went on, I was a coach, and years later, I was literally in Vienna for the vis moot, and my phone rings, which happens rarely when I'm traveling. I get this U.S. call, and it was the president of the New York City Bar asking me if I would accept the role as chair of the arbitration committee of the New York City Bar Association. And I was just shocked. I had been an invisible person, secretary to another committee who had done this side project years ago. And then I get this call inviting me to chair a committee of the New York City Bar Association. So that message is that no matter what you're doing and how invisible you feel when you're doing it, and I didn't care if I was visible or invisible. I did it because I thought it was a worthwhile thing to do. But people notice when you contribute, and it leads to other opportunities.
Great. So be part of the result. That's what I hear, right? Good. And team, you have a kind of a unique background, and as you heard from his introduction, he starting a career as a tribunal secretary, which is kind of new, or at least I haven't heard that very frequently. So how do you envision that role or that path to become an arbitrator? It has something to do with it, or just a separate career?
Sure, yeah. I mean, I think it's a good question because it's not necessarily obvious that serving as a tribunal secretary would translate to the skill set of sitting on a tribunal. I'll come on to that. I thought it would be helpful to set the stage a little bit as to what the role of a secretary is. And I think that getting a common understanding of that might then lead to understanding why I think that there are skills and experiences that come from sitting as a secretary that translate to, I hope, ultimately sitting in the chair of the arbitrator. So starting from the baseline, there is a long history of arbitral tribunals being assisted by secretaries, sometimes disclosed and historically more often undisclosed, or as shadow secretaries. And that practice is, I think, for good right reasons, out of favor today. There is a growing practice of having disclosed secretaries, either members of the same firm of the arbitrator and now a growing community of independent tribunal secretaries, which I think tracks the growth of complexity and size of disputes more generally. And so thinking then about what the appropriate role is, in 2015, the Young ICA published a report about what the appropriate roles and uses of a secretary should be, and best practices about things like remuneration, terms of appointment, and other nuts and bolts. And it's a very helpful document, very thorough, and I would recommend it if you're interested in anything in more detail. But one of the interesting things about the role is that many of, if not most of the guidelines, the big ones especially, approach the role in defining it in the terms of the negative. So what I mean is that the tribunal has a mandate that is personal to the tribunal, and the rules require that the tribunal not delegate any aspect of its decision-making or other personal functions to a secretary. And the other side of that is there are tasks that are appropriately delegable to a secretary. Some rule sets, like the ICC rules, have a list of tasks that are presumptively appropriate. In the LCIA rules, for example, they have there's a requirement that the secretary be authorized with the agreement of the parties to do a specific task. And if that task is, or if another task is not authorized, party agreement has to be sought in order for the secretary to do that. But within that scope of what is the non-delegable, outside of the scope of the non-delegable tasks of a tribunal, there's, I think, substantial gray area that really depends in a lot of cases about the working style of the tribunal, the relationship that the tribunal has with the secretary, and the capabilities of the secretary. So this sort of long-winded way of saying, like as we talked about yesterday, it depends in a lot of cases. But I think that's the foundation for then why I think the role provides a lot of experiences in learning by osmosis, really. Because if you're not participating in the decision-making function, and I think that from an ethical standpoint, this is a very important thing for a secretary to keep in mind at all times. So fundamentally, that's key. And I think that that's one of the most important reasons why secretaries should always be disclosed and appointed with the consent of the parties. So the first thing I think is really exposure to the tribunal side of procedural decision-making. So getting to see complex, thorny issues and how they are decided from the perspective of the tribunal, I think provides a fresh perspective to those of us who have practiced for many years as counsel. You approach these decisions with an advocate's or a partisan viewpoint. And I think that the tribunal's perspective as a neutral, as a person or the tribunal responsible for ensuring equality of treatment, it is a different and fresh perspective. And I think that learning from how that is done and the considerations that go into it are a very important and helpful new perspective for someone who sat as an advocate. Beyond that, some procedural rules or institutional rules do not allow, but others do allow the secretary to sit in on deliberations, not to participate in deliberations. I think that's sort of implicit in the idea that you're not part of the decision-making process. But sitting in on deliberations is, and I have done that, it's a very valuable part of the experience because you get to see how the decision is made. And a lot of what we talked about yesterday with Yves Fortier and Justice McLaughlin, there are a lot of wisdom about how the process is done, but getting to see it firsthand is different entirely. It's a very valuable learning experience for a secretary. And the last one I think is visibility. You do it not because your name will be in the award, but that is a sort of secondary benefit. You have visibility to experienced practitioners, especially in the kinds of cases that I'm working on. They're excellent counsel on both sides. They're very high profile for the most part. They're very high value, and that's why a secretary adds value in that case. But a secondary benefit for the secretary is that you are in front of them. You don't have the decision-making function, but you are a part of the process. And I think that there's probably some sort of secondary or rub-off benefit of being associated with very experienced practitioners, and that they've put trust in you to do that role.
Interesting. We all know that arbitration is a reputation kind of profession, right? So this goes on the same track. So in order to build a good reputation and have this repeated, let's say, appointments, are there any mistakes that new arbitrators should avoid or be, more mindful to not have, Louise? If you have a list.
Yeah,
so
there are about 1 million and counting. But they're mistakes that you should try to avoid. And I thought I would address it in a more positive way than trying to list all the mistakes and talk about it at first, at least on a higher level. My first statement is leave your baggage at the door. And what I mean by that is that chances are most of the people in this room come to arbitration through their legal career, and you have probably done litigation. And so when you actually do arbitration for the first time, you still got that litigation mindset. Even if you've learned that it's not like that, your reactions, your immediate reactions tend to be what you've been living and breathing since the first day of law school. So you're not in court, it's not litigation sitting down, but everything is a bit different, and that means you are freed from a lot of the rules that bind you in court, but that also leaves you with a certain responsibility, a very important responsibility to make sure that the process that you're in charge of is a fair process, that due process is observed, and that the parties go away feeling that win or lose, they've had a good hearing. If it's just litigation sitting down, that probably won't be the case. And the second thing I wanted to mention was consent. The second rule that I have learned from many of the most senior arbitrators that I've worked with is keep your mind open. We heard a bit of that yesterday. So consent is important. The basis of your jurisdiction is consent. The parties have consented to have you decide their dispute, but they have a certain process in mind that they are expecting, and you need to be able to deal with their expectations. And in many cases, when they're from different jurisdictions, you have to take into consideration the different expectations from the different legal systems. And again, going back to litigation sitting down, if you've got a French party and a Singaporean party in front of you, they are not going to have the same ideas about what is a deposition and whether it should be permitted. But not only that, but just things like what's going to be more important? Is paper going to be very important, or is oral testimony going to be more important? Things that come from different legal systems that you may or may not have lived through yourselves. The thing is, a lot of arbitrators are coming in now at a very young age, coming in I won't say directly from school, but at a comparatively young age, say in late 20s, when you've probably got some litigation experience, but you probably also have taken a master's degree in dispute resolution or a special course in arbitration. So you've got a lot of the theory, but when you actually have to put it into practice, you always have to be second guessing, at least at the beginning. The other group is the group of people who've come in from many years of litigation. Many litigation lawyers, for example, Dana, you worked in litigation for 20 years, and then you turned to arbitration, and now you've made the transition. But I think probably when you first started to arbitrate, you had to always kind of think second thoughts because your litigation reactions tend to come back all too quickly. This happens with probably even more seriously when someone has been in litigation their whole life. It comes, they're 60 or 65 or 55 if they're from England, and it's mandatory retirement from the firm for whatever reason. And so you don't want to stop because you like what you do, so you say, okay, I'll be an arbitrator. And, or you've been a judge for a while, and you decided, well, I'm a judge, so I can be an arbitrator. It's the same stuff, right? I just got to make a decision. And so all of those things are things that you have to keep second guessing, and that's why I say the open mind is so important. And in the same vein, but different path, you've got to keep your mind open during the procedure. Sometimes you'll get a submission from a party on some perhaps fairly simple procedural question, and you'll say, yeah, that's a good idea, let's do that, forgetting that the other party hasn't had a chance to address it. And that can cause problems if the other party feels that they've been steamrollered because they didn't get a chance to, even if they agree, to say that they agreed to the suggestion. What else? Okay. Yeah, to always remember the rule of audi alterum partem. Does everybody remember that from law school? You know, listen to both sides. Yeah. Another thing that I find I've heard of, probably experienced to some extent, is with your first arbitration, you're going to be nervous. You're going to be nervous because there's a certain imposter syndrome, like I'm not experienced. I'm maybe less experienced than every other lawyer in the room in terms of arbitration and arbitration procedures, perhaps even in terms of the law that is applicable, especially in international law. You may not know the law, particularly of the merits, and if you're in a different seat, you almost certainly won't be familiar with the law of the seat. And so you've got always these questions in your mind that you have to keep in mind, but you can't let that take away the confidence that you have, that you think you are prepared mentally to do what you're going to do, which is find the best solution for this problem. And that involves things like, well, the title of this topic is Own the Procedure. You have to be, if you're the sole arbitrator, you're in charge. The parties may try to steamroll you, and you have to be able to push back to the extent and say, look, well, this is, unless you agree, I'm going to have to make a decision. If you do agree, and you agree to something which I think is perhaps ill-advised in the circumstances, I may, try to persuade you otherwise. But you have a certain authority as the arbitrator because the parties have given you that, so you need to use it to make sure that the process is good. If you're in a tribunal, I think that the discussion yesterday with Justice McLaughlin and Yves Faultier was really fantastic because I think the two things to remember are patience, as Yves said, and the importance of collegiality, the importance of consensus. But also, again, and if you happen to be chair, which sometimes happens, you may be chair with two wing arbitrators who are much more experienced than you are, who've decided to give you a chance, perhaps because they think that you've got potential. But you've got to remember that you have that authority as chair. You don't want to overdo it, but you need to respect the two wing arbitrators. Always give them their chance to speak. I love that rule about the chair never speaking first, and I think it's really great, especially if it's your first couple of arbitrations, because if you may overstep and really try and persuade one or the other of your position, and it does skew the collegiality if you are not in a balanced situation. And lastly, a couple of two really practical things. If money is going to be an issue in terms of the fees of the arbitrators, where it sometimes is, hourly rates, things like that, a colleague in this, I'm not sure whether the person is here or not, was an arbitrator who was with the other arbitrator, the other party appointed arbitrator, finding a chair. They found a chair. The chair was appointed. Everybody was happy until they asked the chair what the chair was going to charge by the hour, and it was like triple what the other two had been thinking about. So they suddenly had this rather low value arbitration with an arbitrator with ridiculously expensive fees. And what happened? It settled. So that's something to be aware of, very practical. And the other practical thing, there was one last thing. No, that's it. That's it.
Good, thank you, Louise. So Louise touched a little bit on the fact of the scope of and role of the arbitrator and what does that exactly mean. So, Aris, can you share with us your thoughts on that?
Sure. In terms of what it means to fully understand the scope of your role and responsibilities as an arbitrator, and where do you start, an obvious, and you've heard it already from some of the panel members, an obvious place to start is the arbitration agreement. What does it cover? Who does it cover? Are those the parties that are before you? And are there any questions that need to be resolved at the outset about that? That you want to be very clear about that. Christina mentioned, is this a domestic or an international arbitration? And it's actually a question that seems trite, but can fly under the radar. There are situations where, everybody in the room has assumed one thing or hasn't bothered to ask the question, and then the question comes up at the time of a set-aside proceeding, which statute am I under? Relatedly, what is the seat of arbitration? Are there any questions around that need to be resolved right off the bat? That's the framework that you're working with. Are there any questions around third parties or consolidation of proceedings? Those can also affect the scope of what you're doing and your responsibilities sitting there as an arbitrator. We've heard about the rules. What version of the rules are you using? What are the evidentiary rules that apply? Are they just guidelines or are they binding? All those sorts of questions need to be asked and answered and clarified if need be at the outset. The other thing I would add is, are there any timing requirements that you should be aware of, whether those are in the rules, in the statute, or any timing expectations of the parties that you should be aware of? Should you be asking that to ensure that you'll be able to meet your obligations sitting as arbitrator and your responsibilities? So those are some preliminary thoughts that I'd be interested in if what my panel members may have to add on that question.
Anybody interested in adding something to that?
I'll just say that To those who do more litigation than arbitration and want to get a good sense of what a good arbitrator or what should be done in arbitration, doing award enforcement litigation is a fabulous way to learn about how to run an arbitration and issue an enforceable award. And I had the pleasure, if I can call it that, of a lot of award enforcement work when I was in private practice. And I saw challenges to awards that, I mean, went way beyond the New York Convention and the UNCITRAL model law. And I learned a lot about what makes an award enforceable, what makes the process of arbitration and the award itself enforceable. So if you have an opportunity to do that kind of litigation, if you're a litigator who wants to get more involved in arbitration, that's something to try to raise your hand for at the firm.
I'll add to that. In the enforcement and set-aside stage, it's kind of the second area where you'll see challenges to arbitrators. You either see them up front, in front of the arbitrator, or at the end. And so I think when you're an arbitrator, obviously, it's an honor to be appointed, right? Two parties have trusted you with making a decision for their dispute. And there are a number of things that you have to keep in mind to ensure that you're fulfilling your end of the bargain. It's a contract. And one of those things is your continuing obligation of disclosure. I have a case right now. So I've got one case which is stayed, and our party-appointed arbitrator was just appointed by an institution in another case that's just starting. And I'm like losing sleep, in part because we're going to bring a motion soon in the one that stayed. And I'm kind of like, how do I raise this? I need to bring it up. The other side where it stayed has actually become unresponsive. But I'm losing sleep because if nobody raises that this arbitrator has been appointed in another matter that I'm sitting in, then I feel like my award, an eventual award, is at risk. And last week, the arbitrator wrote everyone and said that she was appointed, and I was like, oh, thank goodness. So when you're doing things the responsible way, kind of crossing all the T's, dotting all the I's as arbitrator, whether you know it or not, I think your parties are very grateful. Because at the end of the day, I don't think parties care much about whether you disclose. Like, if there's a problem, I think my client wants to know, when I'm wearing my counsel hat, my client wants to know before and not later. Yeah, I would say just always have your eye on, is this award going to be enforceable?
Okay, let me just make a small pause here and ask the audience, do you have any questions so far? Anything you want to bring up? Have one there. Can we get a microphone? No.
Here, we can share.
Yeah. Thank you.
Thank you so much. We spoke about first appointments, and I have a few friends who say they are shy, they don't want to put themselves out there. We see you on LinkedIn, but we would not create posts and put up on LinkedIn. They join organizations, they never volunteer for anything. How do such people eventually become arbitration practitioners, or we can tell them that it's not for them? Because everybody keeps saying you have to be out there, and there are some people who just can't be out there due to their personalities, probably.
Interesting.
I have some ideas on that. And I think that this also is something that I learned at Arbitral Women, is that if you are not naturally someone who is out there and going to sort of sell yourself in the professional setting, your allies in the community can do that for you. And I see many, many, many colleagues supporting and trumpeting the successes or the talent of their colleagues. So you don't have to be the one to sell yourself or boast about yourself on social media, or, you know, raise your hand at a committee meeting and feel awkward and potentially, you know, not put your best foot forward. You have colleagues who can speak to your talent, your quality, and you should tap those. And I think it's done with reciprocity. I know people will, you know, help each other and share the talents of each other. So look to your colleagues, and that's where peer mentorship or peer relationships really help, as well as senior people.
And I would say it's not so much about getting out there and being boisterous. It's about contributing. So if you contribute, if you help people, this is a profession. We all have an obligation, I think, to bring the profession forward to keep the integrity of arbitration. And the way that everybody is participating in this conference, the way that we participate in task force says in thought leadership, all of that, I mean, it's all with an end that's not just business development. So you actually contribute, and people will see you contributing, and then that's when your peers will say, I know so-and-so, they're so helpful. You know what, we need somebody on a committee. I think it's that you can be quiet and you can write, you can do blog posts, you can review rules. There are lots of ways to quietly contribute, I think.
There's also your performance as counsel in litigation. Many people who do litigation also do arbitration, and it may be that someone has been so impressed by your opposition to their case that they decide that you'd be a great arbitrator for the next one they have. So it isn't all about putting yourself forward. Sometimes just what you do naturally and do it well will impress people.
I might only add one sort of, it's not a contrarian view, but I think that I would group myself in the group of people who are naturally more quiet and wouldn't raise their hand for things first. But I think that getting out of one's comfort zone to do that where you need to in order to achieve the experiences you want to have is also important. So, you know, it's that there is space for all types of people, and I think that we come on to this a little bit later about arbitrator qualifications, but I think that there is and should be space for people of all kinds of different personalities, but there's also space to push yourself.
Good. You have another question here, please?
Thanks. Thanks. I have a question about kind of the practicalities and order of operations of in the kind of what's the first thing you do category once you're appointed, and it relates to terms of appointment, which generally are basically a whole separate question from actually being appointed altogether. And I've seen a number of different approaches. I've engaged with some arbitrators who are figuring out the terms of their appointment at the first procedural meeting, and it's all done kind of in a mix together. I've dealt with some arbitrators who want their terms of appointment solidified before even having the first procedural meeting, sometimes with some kind of pre-procedural meeting, sometimes without. And I've seen all of those approaches. Sometimes they work, sometimes they cause their own problems with what authority does the arbitrator actually have at given times in their appointment. Is there any particular way that you prefer to go about managing that? Best practice, worst practice, anything like that?
I'll give an example from when I was counsel and saw it work well, where it's a bit of a hybrid of what you're describing, where the arbitrator sent a draft to the parties, said essentially be prepared to provide comments on these. Is essentially an invitation of, if you have an allergic reaction to any of these, let's discuss it at the first procedural meeting, and then following that, exchange written comments, try to come to agreement among the parties based on the draft that was given, and then if need be, we'll have another procedural meeting to iron out the final details. But that I thought worked really well.
one of the advantages of an institution is that very often the institution will provide the terms of your contract with the parties, and that saves a lot of trouble. You don't have any negotiations about fees and things like that. It's all out there in the first place. So I think that's one thing. If you don't have that, I like to send the terms of reference and get that out of the way before the first procedural meeting. Not always possible. I just had a case where we actually had an hour on the terms of reference, and at the end of it, they couldn't come to an agreement, and so I didn't go ahead with the case.
And the terms of reference, just to orientate it, that's for ICC cases, right? No. Or, oh,
No,
so you do,
should
okay.
be-
I'm sorry, terms of reference or terms of appointment, but the institutions will have their terms of appointment.
Just one addendum on that. For anyone who's interested in working as a tribunal secretary, this is an area where there are some pitfalls because different institutional rules have different expectations about when the secretary will be appointed, how they will be appointed, and what they can and can't do before they've been appointed. So, and this is probably more relevant for folks who are inside of a firm who are working with an arbitrator. But certainly, if you have this as an aspiration, look to the Swiss Arbitration Association has published a lot of good guidance about best practices, and the LCIA rules are particularly strict about this. So,
Can I ask you about tribunal secretaries? How do you go about getting those positions?
well, I think in my case, I was lucky because I was in the ICC's Advanced Academy, and I overheard somebody speaking about how a senior arbitrator that she knew in New York was looking for somebody, and I said, "Hey, I overheard you saying this, and I actually do that." And then she put us in touch, and ever since then, I've been working with that particular arbitrator on a number of cases, and then through the co-arbitrators on those cases, I've also been appointed in other cases. So it's been a sort of snowball that rolls naturally, but I think fundamentally it's about being out there, being ready to do it, and being interested, expressing that, and then doing the best that I can do.
Good. And just sharing a piece of experience. The ICDR has guidelines for tribunal secretaries, and when we had the discussion of whether those guidelines were needed or not, there was a pretty interesting conversation between the committee members because some of them said like there was not needed. We were kind of pushing for arbitrators to have secretaries, and another part said like, you know, this is a very, very good opportunity for young practitioners to get into cases that they would probably not have access to unless they act as tribunal secretaries. And there's an educational part there that we need to take care of. So it's an interesting position as far as I've learned. So okay, and then whenever you get your first case, we may get into a place where we need to actually establish credibility and authority between the parties. And we may put in place some strategies in order to get that. And I would like to ask Christina for your experience on that. I guess when we were preparing the panel, you shared an interesting experience.
So in terms of having that authority, I think always remember, and again, this is still the same grounding exercise I keep coming back to, the parties have asked you to do something, and you are given authority through their agreement, through the rules, etc. I do find, though, that much like being counsel, preparation is your friend. Prepare, 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 and confidence will follow. And then the second part is formality. So I mean, anybody who knows me, I'm not a very formal person. I'm an open book. But when I'm sitting in a chair as arbitrator, I think it's very important to really slow things down, and formality is your friend. I think it creates a certain amount of professionalism over the procedure, and interestingly, I think also authority. So that's really all I have to say on that. And I wonder, does anybody else want to weigh in? Iris?
On the formality point, I also want to add, it has an egalitarian effect among, not just as between the neutral and the parties, but the parties among each other, because you don't want to be in a situation where there is, even subconsciously, a degree of informality between an arbitrator and one counsel or one side's counsel that is then perceived, rightly or wrongly, by the other party to be a bit partisan. So I think just, even if it feels a little bit artificial, having that layer of formality does guard against that.
Yeah, and part of it is entering into the arbitrator space where you are just, you kind of have to be empty, right? And you have to listen. You're no longer an advocate. And so I think you actually need to very consciously get into that mindset, especially if you're an advocate regularly. I learned in forever ago in my criminology class in undergrad that Dutch judges, as soon as they enter the courtroom, they no longer use their names. And part of that is so that they can get into the mindset of leaving their personality at the door and becoming kind of a clean slate to hear a case. And I like that imagery, and I do think you go in with that kind of formality because it is, you need to have a very fresh and open mind.
I've, in many cases, been on first name terms with my fellow arbitrators and sometimes with the counsel. And it's always last names inside the room.
I have observed that sometimes very senior arbitrators can have a very casual style that can be effective because it's disarming sometimes when counsel are being difficult with each other. I've seen that happen, and I thought that was a very effective style. It's not necessarily the style that I would adopt, but I think that depending on the type of circumstance, that could also be an effective style. So.
I do think with seniority, formality can sometimes go down. We had one very senior arbitrator. I'm looking to see if the other counsel's in the room. It was a document production fight over a Redfern schedule, and it was just before COVID, so it was in person. And the chair came in the room and said, if you guys don't decide what documents you're going to produce, I'll decide, and no one is going to like it. And then they went and they sat in a room for 5 hours, and we came to an agreement.
We have a question, please.
Just to follow up on the first name concept. So I'm being called by my first name in a lot of arbitrations where I know the counsel, particularly in the subject matter area of franchising where I'm an expert. But in other types of arbitrations, it's much more formal. Would you correct, like at the outset, would you, maybe at the beginning of the case conference, would you say, like how would you change the dynamic if they're calling you by your first name? Or would you bother, or would you just continue?
Well, I would set the stage by introducing my co-arbitrators as Ms. So-and-so and Mr. So-and-so. So that already is a hint that they shouldn't be calling us by our first names. If they don't take the hint, I wouldn't necessarily correct them, but I would continue to call my co-arbitrators by their last names. And also, I might say, well, Mr. So-and-so, if I've understood the question. In other words, not, well, Joe, I didn't get it. You know?
I've had that same experience, and I've not corrected them. And I think it happens more often on Zoom, where your name is appearing in the bottom of the box. And this was in the context of a discussion about some alternative approaches to a procedural issue, and several members of the tribunal had thrown out different ideas, and somebody, one of the counsel came back and said, actually, I'd like to, hear more from Dana on that point. And I was like, I don't know you. Like, why are you calling me Dana? I was afraid I was going to be challenged by the other side. And I really honestly, maybe he knew me from a bar committee or knew my name from a bar committee, but I swear it was my name on that box. We were on Zoom, and it's so easy to just see that first name. So I wouldn't read too much into it, and I did not read, or I've never seen it to be used in a disrespectful way. And arbitration is supposed to be less formal. But I agree that people should not be using first names. But if it happens, I wouldn't make anything of it, and I would just reinforce the use of last names, like Louise said.
In a mediation, it might be a completely opposite approach. I would say, well, I'm Louise. Can I call you Peter? Or can I call you Mary? And see whether I can get everybody on first name basis, because it tends to minimize the formality.
I don't think there are any hard and fast rules. I think everybody needs to figure out what works for them and read the room. And it could be that in the franchise disputes you're in, it's a smaller, kind of very specific bar. I wonder, in construction, there might also be, the first name use. I'm looking at Barbara. So I think, going back to the theme from yesterday, it does depend. But I would say if you're looking for a way to have authority, formality is one tool.
We have another question there.
And for whatever it's worth, to me, it always depends on if parties are there, like the clients are there, very formal. Unless the mood says otherwise. If it's just the lawyers, I don't care as much.
It also depends on the context. I practice in Asia, and first name is last name sometimes, and sometimes there's no last name, there's no family name. So it's always better, I think, sometimes to formally ask people, how should I call you, if it's not clear, or if you're not familiar with the practices of every culture.
I might still say Mr. Chin or Miss Young, because for the other side, they won't understand why I'm calling them Kim or Young when they're getting addressed as Mr. So-and-so.
Yeah. So, and then moving to the next step on the procedural timetable, Dana, are there any tips you want to share in how we should manage that efficiently?
I'm not sure I'm best positioned to do that, having lost the competition earlier today, but
I was about to say that this topic follows you, so.
I've shared some of my views of the timetable, that I do think the timetable should include a window at a good point for negotiation or mediation. I think when you receive a jointly proposed timetable from counsel that is over the top with a lot of components that are really borrowed from litigation, that's when I think it's appropriate to exercise your role as arbitrator and keeper of the process to eliminate those. And I've done that, and it's something you think about when you're deleting 6 or 8 rows from a table of a procedural timetable, but you really want to try to include the important milestone events. You want to leave enough time for them, but you want to do it efficiently. And you take the opportunity at case management conferences to remind counsel if there's a need to make an application for an additional step or some aspect of the process, you have that right. I like to put in my procedural order that, you seek leave in a very short letter. You don't just file an application, you seek leave, the other side is given an opportunity to comment, and then the tribunal decides whether, if it's going to be a substantial application, whether to grant leave, and then build a schedule for that. But otherwise, I keep it largely high level and try to allow a bit more time than I think is needed, because especially when it comes to issues relating to disclosure, I know that, and I emphasize the need to meet and confer, not just once, but multiple times, that the council really need to work together, both on the documents that they will agree or not agree to produce, but also on the manner of how they're produced, and ESI protocols, and all of those things that need to be done by council. They really need to develop a working relationship, or else, I guess, as was said, if I have to decide it, it's very hard to really decide something in a way that comes out in, how either side would have chosen it if they had agreed themselves. So I think procedurally that's what I would try to do, and I think everybody starts a schedule with trying to agree on when is the hearing going to take place, if this goes all the way to hearing, and that gives you a good sense from each side as to how complex or how procedurally intensive the case is going to be, and you can really test that, by having conversations with both sides and choosing windows for the hearing. Sometimes, you get a procedural schedule together with ease. The first conference is less than an hour, and you come out with a schedule, and the components, and it's going to be really straightforward. Other times, you come out of a procedural conference with just, a lot of disagreement, and you send them back to confer, but the tribunal is also going to confer. If you're the sole arbitrator, you take a look at what, you wrote down as what happened, and you already have an idea, like, if they don't agree, this is what I'm going to propose, and it's going to be a pretty forceful proposal. So you could do that, and the hearing dates really should stick, short of a settlement or something very close to a settlement that people have confidence it makes sense to pause those hearing dates, and I'm very reluctant to do that, short of being something signed and sealed. And when it comes to document disputes, if I hear nothing after the deadline for the submission of a Redfern or Stern schedule, or any schedule you want to call it, that's the document. If they have no disputes relating to document production, I suspect they're talking settlement. And I will follow up a week later, not the day after, but if it's like a week's gone by and they haven't filed Redferns, I just check in with them. The deadline was last Friday. Just wanted to make sure that everybody had the schedule front of mind. And inevitably, I get an email saying, we've been talking settlement. So that happens too.
Good. Does anybody want to add something on that topic?
I guess I might just ask, why wait? The timing is the timing, so why wait for the parties who have blown a deadline to get back to you?
Because everybody's human, and I don't know why they've missed a deadline. Usually they don't miss deadlines, so I figure either they're talking settlement or someone's unwell. I just don't chase them down the next day. Now, if they file something 4 days late with no explanation, especially if it's a simultaneous submission deadline. So if one side files and the other side doesn't, or something, then I might say, what happened? Is respondent submitting anything, or do we only have disputes coming from claimant? That's when I would be more immediately responsive. And then also, I think this is just a pet peeve of mine, but I don't know, I'd really be interested to hear from counsel. Do you really want the tribunal to confirm receipt of every single email you send? Or can we just presume that the email's been received, or I've had some arbitrators just say, anything she says, that means I got it too. But there's this sort of knee-jerk response, I've received your email, or I've received your Redfern. Yes, exactly. And it's just your mailbox is full of receipt acknowledged. Like, hopefully we all get our emails and process our emails. You know, I think the more meaningful response is, you know, I received the link. I was able to download, you know, all but 3 of the exhibits. I'm having trouble with X, Y, and Z, you know, and then counsel can help get it to you in a different form. Or I actually ask my co-arbitrators before I do that. We all kind of confer, like, yeah, we're having trouble with Exhibit 96 too. I don't know why. And then we go to counsel and ask about that.
I don't mind the receipt acknowledged. I think you're just papering the record for a fair hearing and just ensuring, the arbitrator's just ensuring that they got every party's documents, so there's no element of unfairness. But only arbitrators do that. I've been on a case where the arbitrator unfortunately got back to one, and there were a lot of counsel, and so they got back to one set of counsel. And so a few days after, we were saying, you know, we were expecting a decision, what's going on? And the arbitrator immediately got back to us, was very apologetic. I actually reached out to the other side first to say, have you also not heard anything? And they were like, yeah, we got the decision. Yeah, so it was nothing to fight over. No, it wasn't, it was an interim decision. I believe it was document production. But again, we managed it, and this also, I think, for counsel, like, we could have fought about it, but like, there was no need. No one was prejudiced. We just moved on.
Well, I'll say one reason that I would not send receipt acknowledged is if I'm traveling and I see on my phone that something's come in, but I'm not at my desk and able to actually open it and download it and confirm that I've actually received what I believe I've received, you know, then I tend to wait. And if it's just a couple days, you know, I'll just say, you know, confirming receipt and successful download of the documents.
Maybe this is going to be our best idea. Like, raise of hands. Should arbitrators always respond with receipt acknowledged? Huh.
Okay, I'm going to fill your inboxes going forward. I might say, like, in transit, I see the emails. I've received emails from both sides, and I will get back to you by Monday with respect to whether the download's successful.
I generally do receipts because I get hundreds and hundreds of emails every day, and a lot of them go to a filter which says, read this when you have time. And so when I get it, I say I've got it, and it might be a day after they sent it if it's gone to the wrong place. So
We have a question
I think
here.
there's-
Mary?
I was just going to add, I always thought it was kind of goofy as counsel, but I've had 2 experiences since I've been sitting as an arbitrator, which has just been the last 5 years, where one of the panel did not receive an important submission and didn't realize that once it was a winger and the other time it was the chair, and the other 2 were waiting for the chair to send out a receipt acknowledged on behalf of the panel. And 2 days after, one of us sent a note saying, not sure if you're traveling, did you want us to send that out? And they were like, what are you talking about? So oddly enough, it does happen that things do go awry. So ever since then, I've been a fan because it's important to know that people actually get things.
Well, I think that goes to the communication amongst the tribunal, which is really important. And I think it's good that if co-arbitrators have received something, you know, that they touch base with the rest of the tribunal and make sure that everybody's received it and everyone's successfully downloaded it. Or if they have trouble, you know, one person's more successful than the other, they send Exhibit 97. I think that if there is a problem, like, you want to flag it as soon as possible. I also think that with respect to those communications between tribunal members, I am a bit over the top on this, but I'm in all caps, confidential, tribunal eyes only, and make sure to have stripped out all of the council email addresses. I have seen more than once an email from one arbitrator to the other arbitrators being like, can you believe this came in? Or like, just things happen. And I'm like, no, 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 no. I'm like, yeah, you really, as an arbitrator, I know everybody's busy, but you just have to be super careful. Like, you do not want the parties or counsel having any access to internal tribunal communication. So I use that all caps. It sounds very alarming. People are like, you're really like yelling at me. I'm like, no, I'm not. I'm just making sure that when you go through your inbox, you know which ones are coming from internally as opposed to the ones going out to the parties.
Good, good. So we could keep talking about the procedural issues, but let's get back to our topic here. And I would like to ask Iris on what are your views on practicing and sitting as an arbitrator simultaneously?
I don't think there's a one-size-fits-all answer, and I think what makes sense to do both depends on where you are in your career trajectory and what type of practice you're aiming to build. Practicing as counsel while accepting appointments as neutral obviously comes with challenges. Conflicts is a big one, particularly if you practice in a larger firm. Balancing workload is another one. But I do think there are also benefits, particularly if you're nearer to the start of your career as trying to get neutral appointments. There is, and you've heard some of these themes already, I think there is real value to laying the groundwork for your experience and reputation as neutral while you're doing the counsel work. And by counsel work, I'm referring to arbitration work as counsel. You're building a body of both substantive experience and knowledge of whether it's a particular region or a particular subject matter, familiarity with particular regions where arbitrations are either taking place in a particular industry or seated, getting to know, making relationships with the other practitioners in that region, I think is important. Also, and you heard it earlier today, acting opposite and before other arbitration colleagues as counsel is a way also to build up your reputation. So there is value to that. And then from my perspective, you layer in methodically the neutral specific aspects that you want to build up, whether that's training courses or accreditation or networking within the arbitration community, getting those initial appointments on perhaps simplified proceedings to start. We heard a little bit about that earlier today. And I think of it as a path rather than a diving board. And from my perspective, if you think of it that way, I think there are, it comes with challenges, but I think there is also some real value in doing both. Other perspectives?
Anything to add to that?
I mean, I guess not speaking from having sat as arbitrator, but having been on the side of the tribunal and observed that and had some experience seeing it from that side, I think it is tremendously helpful as an advocate to see how the decisions are made and what is important, and from a framing perspective, how you write your advocacy and how you present it in a hearing, being aware of how that might land for the tribunal it's very helpful to see it from the other side. So I think it's both salutary effects in both directions, but I think sitting as an arbitrator or seeing things from the tribunal side is a tremendously helpful experience as advocate.
And on that point, there are often a lot of emails that come in from the associate throughout the lifespan of the arbitration. And then at the hearing, it's the lead lawyer who's doing all the, the hard cross-examination and such. But it's very clear that the rest of the team and the lead senior associate on that, or whatever the title is, that person has done a lion's share of the work. And it's really nice at the hearing when that person is given a speaking role. And I've been in that role the person sending those emails at 11:59, transmitting, anxiously, the attachments, and is it going to work, and then like now I'm receiving them and like trying to download them. But then I got to actually, do cross-examination and handle witnesses at hearings, and the tribunal made a point at the end, not only to compliment counsel generally on their professionalism, but to make a point that both sides had included junior attorneys on the team in speaking roles, and that they really appreciated that. That was very well done, and they'd like to see more of that. So I think all of us can do that to encourage the inclusion of the younger members of the arbitration community, both as counsel and as arbitrator.
Yeah. And team, let me just ask very quickly to share your thoughts on to get that arbitrator and to get new arbitrators appointed. What are the topics or considerations you make on that decision?
I mean, obviously, it's a very nuanced question, and it will depend on whether you're trying to agree a chair or trying to appoint a party-appointed arbitrator, and the circumstances of the case will drive a lot of these considerations. But I think yesterday's discussion was very insightful, and it left me with the impression that a lot of the conventional wisdom about what might be an effective arbitrator choice might miss some of the important characteristics that are going to lead to a more effective decision-making process. And as well, one would be, I think, pertinent to this discussion is really drilling down on availability, because if you have a senior arbitrator who is willing to take a case that's smaller, they may not get to it in the same amount of time. They may not have the same level of attention for that dispute. And so that's one consideration I think is often lost, is availability. Certainly in very large disputes that may make very little difference in the end, but that's one I think should be added to the mix. Another I think that would be effectively added is treating the conversations with prospective arbitrators. Usually they focus on past cases that are similar or have involved similar issues. They don't delve into a lot of detail, but asking about that arbitrator's approach to deliberations. So asking for examples of how that person may have approached a deliberation before. What is their philosophy about that? Just probing what kinds of things, and this is getting at, again, what the discussion was yesterday about, how effective decision-making is done in tribunals. Or even asking questions about, what kinds of, if it's an international case, again, what kind of difficult situations have you encountered in cross-cultural competency issues, and how have you addressed them? They're a little bit more, they don't go to the merits of the case, but they might give you some insights about how that person has experienced an issue that might come up in your case.
Great, thank you very much, Tim. And just to close and taking advantage of Louise' knowledge on supporting and increasing mentorship through Arbitral Women, I just want to ask for your thoughts on the importance of mentorship, just to close this session.
Well, mentorship, I could talk to about 15 minutes, but we don't have 15 minutes. But basically, mentorship is really, really important. And whether we are aware of it or not, most of the most important stages in our careers involve some sort of mentorship. It's because somebody believed in you and was willing to push you forward or to suggest you for something. Someone who is willing, perhaps, to put themselves on the line by saying, I think you should choose this person because I think that they're good and they can do the job. But mentors can do a lot of things. They can give you advice, professional advice, life balance advice, confidence advice. They can push you to own the role by reassuring you that your imposter syndrome is not only you, it's most people the first time they walk into the room, and maybe the second and the third and the fourth time as well. So mentors are really important. Traditionally, men have mentored other men because they have social activities after work, which often women weren't included in. And so that's one of the reasons that we started the mentoring program in Arbitral Women, because we needed to have some kind of mentoring system where women did have access to people who would support them in that way. We can go on, but I'm just saying, if you want to know more about mentoring and you are a woman, join us.
Great, thank you very much. Please join me congratulating our panel, and thank you very much for your attention.